Good afternoon, Mr. Romero. We're ready to get started if you are.
I sure am, Judge.
All right, terrific. Thank you so much. We'll go ahead and get started at the top of the docket. We have Laurent, Miss Laurent.
Judge, her bond was posted.
She posted? Okay, thank you.
Ms. Laurent is here present, Judge.
Oh,
Her bond has been posted.
Mr. Romero, will you let her know her bond's been posted so she can go ahead and
Someone
get
posted your
processed?
bond, you'll be released today. Good luck, ma'am. Okay.
All right, I'll find probable cause at this time. All right, next we have Deborah Ferrero.
Medical reset.
All righty. Reset her to tomorrow. All right, Christina Velasquez.
Mr. Christian Velasquez is here present, Judge, at
Okay,
Maine.
sorry, Chris, there's an A at the end
It's
there.
the
That's the
middle
middle
initial.
initial, I guess. Sorry about that. All right, so, this is interesting. It's a $5,000 bond on a misdemeanor.
It's, Your Honor, I checked it out in Odyssey. It's out of drug court. It appears Mr. Velasquez missed his first court appearance after being before Judge Zeller and signing all the paperwork, so maybe that might have something to do with it. I don't know.
Okay,
Judge,
yes.
if I could be heard when you have a chance.
Of course, there's a status, just so you know, sir, apparently you must have missed a court date with Judge Zeller. I was surprised at the amount of bond, but it appears Judge Zeller may have issued it, I'm not sure, but you do have a status hearing with her on, October, is that 19th or 17th? 17th.
I think it's the 17th, Judge. Our clerk
17th.
crosses her sevens.
Yes, at 1:30 in the afternoon. Mr. Romero?
Judge, in speaking with Mr. Velasquez, I believe Mr. Velasquez's case, this misdemeanor cannabis, is actually in drug court. My understanding is he missed the court date, which was scheduled on July 18th. Unfortunately, due to hardship, he's homeless. He never received notice, so he was unaware that he had court on that day. One of the things that he's trying to do to get back on his feet is he's trying to be employed. He just got a job interview working, trying to obtain a work at Chipotle's. Chipotle's contacted him and let him know, I believe, unfortunately, that he was going to be ineligible to work for them because there was an outstanding capias. That's when he found out. When he found out he had an outstanding capias, he came over here to the main jail yesterday and actually surrendered himself and turned himself in.
Okay.
Judge, he's 20 years old. Right now, he's trying to save up money and going back to Sheridan Tech in order to obtain his GED. That's what he wants to do. Judge, considering this is a misdemeanor offense, it's a possession of cannabis, I told him at this point one of the benefits of drug court is if he successfully completes it, this case will be dismissed. He's asking, Your Honor, at this time if you would consider resolving his case for a withhold, take judicial notice of time served.
And what's his background? I mean, because honestly, given the fact that he's turned himself in, if he wants to continue to try and go through drug court to get this off his record, I would release him and give him his hearing date and let him go see Judge Zeller one more time and give him a chance.
If I can ask him, because I know drug court is really
It might not
intense.
be available.
Let me ask.
I'm sorry?
It might not be available anymore. I was reviewing the agreement he signed, and it does mention if he has a capias status for any period in excess of 30 days. And I understand I certainly understand he turned himself in. I just wanted to advise the court, and I'm sure this was what was relayed to Mr. Romero. Mr. Velasquez was in court when he got his court notice for the July 18th hearing date.
Okay. Mr. Romero, if you want to talk to him for a few minutes, I'm happy to either skip him over or go ahead and resolve his case today, depending upon what his background is. Obviously, if he was eligible for drug court,
He has no history.
background. So I'm happy to resolve it if he wants to do that.
Judge, I've just explained to Mr. Velasquez, just wanted to go over certain things, just making sure there's no collateral issues, and those are the questions I looked into. I don't think there's any sort of collateral issues, and in discussing this with Mr. Velasquez, he wishes to resolve his case today with the withhold and take judicial notice of time served.
All right, very good. Sir, will you please raise your right hand to be sworn? Do you solemnly swear a firm testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can lower your hand. You've had an opportunity to speak with your attorney and get his advice, and you also heard the two options that I presented to you. At this time, after speaking with your attorney, you're interested in resolving your case today for a withhold and time served?
Yes, ma'am.
Okay, you understand that you have a right to have a trial in this matter, to go forward with the trial, have the state bring witnesses to prove the allegations that they've made against you. You're giving, by pleading no contest, you're giving up your right to that trial. Do you understand that?
Yes, ma'am.
Is anyone forcing you or threatening you in any way to plead no contest here today?
No.
Are you satisfied with the assistance of your attorney?
Yes, ma'am.
All right, are you pleading no contest?
Yes, ma'am.
All right, I'm gonna go ahead and accept your no contest plea as knowingly and voluntarily submitted. I'm gonna go ahead at this time and withhold adjudication, sentence you to time served, and give you a year to pay back your court costs, okay?
Judge, are you withholding? Or
I'm withholding,
Okay, thank you.
okay? All right, sir, good luck to you and good luck getting that job.
Thank you. Good luck, sir.
All right. Oops. Next person we have is Andrew Culverwell.
Mr. Culverware is here, present, Judge. I
Bond
mean,
is
he is approaching. He declined the service as a public defender. He's gonna
Judge,
hire.
his bond was posted.
Sir, your bond was posted, so I don't, you're entitled to have a lawyer represent you at this hearing and to go through everything, but since your bond is already posted, I suggest that we just, move along so you don't, and you can hire your own attorney for your hearing, okay?
Yes, ma'am.
All right, very good. I'll find probable cause at this time. Good luck to you, sir. We have Giovanni Pietro Leone.
North Broward, Judge.
All right. Mr. Leone, you currently have several charges pending. The only charge that carries a bond with it at this time is the possession of methamphetamine at $1,000 bond. I've reviewed the probable cause affidavit. I find probable cause.
Your
Mr.
Honor,
Reedy,
the defendant is currently being supervised by pretrial services in case 177045 MM10A, one count of battery and one count of resisting without violence.
can you give me that case number again, please? I missed it.
177045 MM10A. It's in front of Judge McHugh. It was a battery dating violence. He was placed on pretrial supervision. Based on this court's finding of probable cause in today's case, we ask that his pretrial status be revoked. He's been on pretrial, Your Honor, since last month.
Okay.
Judge,
Mr. Reedy, I'm assuming you were unaware of this when you.
no,
said
I was
that.
aware of it.
Oh, you were, okay,
Yeah.
sorry.
Yeah, I looked up Mr. Leone, and our office represents him on that misdemeanor case.
So does that mean now I need to set bonds for him on the other case?
Well, you don't have to revoke his pretrial release if you don't want to, Judge.
You don't
He
have to
has,
set bonds if you don't want to. You can hold
Yes,
the bond and he could go before the presiding
Okay.
judge.
or you can put a bond on the misdemeanor case. It is a misdemeanor after all. He also has some medical issues that I'd rather not discuss in open court that are going to require some attention. And he's also given me the number of his father, who I tried to call a little while ago. I left a message. He believes his father will be able to bond him out if the court sets a bond on his misdemeanor case.
Well, Your Honor, I can tell you his bond, if the court's inclined to set a bond and not hold no bond, his bond was originally set at $5,000, so I would just ask if he's not on pretrial, that his original bond be placed back on.
Well, my biggest problem is that while he was out on bond and or pretrial release, he picked up a new charge. So I'm not inclined to give him a bond on the misdemeanor charge. I'm gonna go ahead and hold him no bond on the misdemeanor charge and maintain the $1,000 bond on his possession, until he can be brought before his judge. So I guess I give this back to you?
Yes, Your Honor.
If I'm not mistaken, on that case, he currently has an arraignment scheduled for October 19th.
Okay, well, he'll maintain that,
Right.
hearing date, and he'll see Judge McHugh, and, then he'll get a new court date with regards to this new felony
You can
charge.
put this with that and give it to
Okay?
the clerk.
We'll have somebody up to see you soon, Giovanni, and I'll be trying to reach your father.
All right, thank you. Good luck to you, sir. All right, and then we have, first name Giovanni Fletcher?
Mr. Fletch is here, President Main Judge. When I looked in the system, I saw his bond was posted. I don't know if confinement status can verify that?
Yes, his bond has
Thank
been
you.
posted. So, sir, I'm finding probable cause, and they'll process you for your release, okay? Good luck to you, sir. Joel, I'm not even gonna attempt it.
It's a Saint
Mr.
Hilaire.
St. Hilaire.
They just don't put the
Hilaire,
dot there.
thank you. It's all pushed together, but I'm assuming it needs to be separate. So here we have, possession of a weapon or ammunition by a violent career criminal, those 2 counts, and then tampering with or fabricating physical evidence on count 3. Counts 1 and 2 have a, predetermined bond of $250,000 per count for a total of $500,000, and then the 1 count of $1,000. I'm assuming the state wishes for me to maintain those bonds?
Your Honor, I am. I'm also going to be requesting, should he post these bonds, that he be supervised by pretrial with a GPS monitor. The reason being, and I'm sure, the court has the same paperwork that was provided to myself and Mr. Reedy from the Department of Corrections, verifying that he has been classified as a habitual violent felony offender. And that stems from, Your Honor, well, first, in 2014, he was convicted of possession of firearm by convicted felon. He was sentenced to 3-year state prison as a habitual offender. In a separate case in 2014, he was convicted of tampering with evidence and sentenced also to 3 years state prison as a habitual offender. He was just released from Florida State Prison May 7th of this year. Additionally, Your Honor, in 2012, Mr. St. Hilaire was convicted of aggravated battery, shooting at or throwing a deadly missile into a dwelling or a vehicle, and possession of a firearm by a convicted felon. He was sentenced to 2 years state prison as a habitual violent offender. In 2009, he had a strong arm robbery. And in 2009, he had delivery of cocaine. Based on his so I'm making the request based on his recent release from state prison. One of those offenses is the same offense he's before the court on today.
Thank you. Anything, Mr. Romero?
Judge, I do. I mean, the bond that's currently set is over $500,000. And I do understand from Mr. Lender's concerns as far as his record. However, in speaking with Mr. St. Hilaire, yes, he's been residing in South Florida basically his whole life. He's living in Lauderdale Lakes with his mother. His mother is the person that right now financially supports him. However, she's on disability. Right now, he's trying to look for employment until he actually gets a 9-to-5 sort of job. He's actually doing landscaping whenever he can, and whenever he can manage to get some sort of employment with landscaping, he gets about $80 a day. This individual, from what I've been advised, I understand he's been in prison. But what he told me is when he was 18, he started working. Now he's 27, so he's been in our workforce for about 9 years now. I asked him out of curiosity, what do you think you've made in your lifetime in those 9 years? He believes it's probably, and this is like on a very high average, I'm assuming he's probably made under $40,000 his whole entire life. The bond is currently $500,000. That's financially tantamount to no bond for this particular individual. Judge, I'd actually take his financial resources into consideration, the fact that he's lived in our community his whole life, and at this time I would ask you to lower the bond to something more reasonable for Mr. St. Hilaire.
And I can appreciate the circumstances, but given his record, I believe that the bonds are appropriate and the GPS recommendation is warranted. So I'm gonna go ahead and leave the bonds as is, and in the event that he was able to bond out, that he be placed on GPS monitoring. Good luck to you, sir. Benjamin Schmidt.
In light of all the things that the PD just told the court, will the court waive the cost of the GPS should he ever post up on the
Yes,
DVD?
ma'am.
Thank you.
All right, we have Mr. Benjamin Schmidt here. Mr.
Yes,
Schmidt,
Judge.
I don't think I'm gonna be able to help you with much of anything. It appears that the judge that's assigned to your case asked that you be held no bond and brought before them, if you were to be picked up. And, you have some violations of probations on a couple of different cases. You do have your next hearing is next week, is October 9th at 9 a.m. Good luck to you, sir. Monty Charles Waldman.
Mr. Waldman's here present, Judge. I mean, he is coming up.
Good afternoon, Mr. Waldman. You've been charged with an aggravated battery with a deadly weapon. And at this juncture, this is a no bond hold. I need to make a, the capias was issued as a no bond hold. I need to make a decision regarding the facts and circumstances of the case. Mr. Linder, can you please tell me about Mr. Waldman's background?
Yes, Your Honor. First, as far as Mr. Waldman's criminal history, out of Broward County, 2006, he was convicted of 2 counts of harassing phone calls. In 1998, he was convicted of aggravated fleeing and eluding, resisting with violence, battery on a law enforcement officer, possession of cocaine, and resisting without violence. He violated probation, was sentenced to 31 months Florida State Prison. He also had 98 possession of cocaine, violated probation, 31 months state prison. 1996 battery, criminal mischief, resisting without violence. Your Honor, I'm showing, one moment. In 2013, an individual sought and obtained a permanent injunction order of protection against Mr. Waldman. Getting hits out of, I just want to see what they're for, out of Georgia, New York. There was an arrest in '04 in the state of New York for aggravated harassment. I have no disposition. Your Honor, based on his criminal history, the allegations in this case, the level of violence, the strength of the evidence in the case contained in the probable cause affidavit, and Your Honor, I would note, Mr. Waldman was arrested in Kissimmee, Florida, so I have concerns about his ties to the community. The state would be requesting, also noting, I'm checking his DHSMV records, and his mailing address and residence was last updated in 2012, showing a Dade County address, so I don't know where he resides, but the state would be requesting a $50,000 bond in an order of no victim contact.
Mr. Romero.
Judge, in speaking with Mr. Waldman, he's 52 years old. He's been residing in Florida for about 25 years now. He's a certified public accountant. He's a CPA. Unfortunately, he fell on, from what he was briefly telling me as far as his life story, he fell on very hard financial times. He declared bankruptcy because of back taxes. His home was actually garnished and taken away. So unfortunately, at this time, he's homeless. He's been homeless for a couple of months now. He tries to get jobs wherever he can with accounting side jobs, and on a great month or something like that, he can make up to about $1,000 a month. He owns, he has no money in the bank. His only sole piece of property is he owns a 2007 BMW with 133,000 miles. He says as far as the exterior and everything like that, it's not in great shape at all. So he thinks the resale value on that vehicle is very, very little or limited or small. Judge, I believe what he's asking Your Honor to consider is setting a $5,000 bond on his behalf.
Thank you for your presentation. Unfortunately, given the circumstances and the lack of ties to the community, I'm going to go ahead and accept the state's recommendation of the $50,000 and the victim's name so that I can indicate.
One moment, Your Honor.
It's all blacked out.
Yeah, I can get it from my system.
Yes, sir.
As far as I know, Your Honor mentioned his ties to the community. As far as when I told you on a good month, as far as the $1,000 he does accounting for individual people, he has clients actually here in Broward County that he works with. He also has family here in Broward County. So, I do not believe his contacts are limited, but he does have contacts, and Judge, so I'd ask you to, take that into consideration, reconsider a lower bond.
I understand, but given the circumstances of what Mr. Linder explained to me about the addresses and being arrested in the Kissimmee area, I don't believe that there's sufficient ties to Broward County. So I'm gonna leave it at the $50,000, no victim contact. Sir, you're not allowed to have any contact with this particular victim,
Joseph Burgess.
Joseph Burgess, either directly or indirectly. You can't try and send him a letter, text message. You can't have anyone else try to contact him or in any way, shape, or form. If you violate the terms of that, if you violate the terms of the no contact order, I'm just required to tell you these things and get a verbal response from you. If you
I really
violate,
wish to threaten and come after
Do
me.
not talk
I
about the
really
facts.
wish he didn't come after me and
well, sir, your lawyers will present your case at court, but at this juncture, this early stage, I just need for you to stay away from him for the time being, okay? He's on mute. As soon as he stops talking about the case, if you'll just let him, well, for the record, I indicate that he appears to have heard me and that he understands the warning that he have no contact with the particular victim. Thank you, Mr. Romero. Then we have, a Mr. Mark Ford.
Conte, Judge.
Thank you. All right, we're switching over to Mr. Ford. Good afternoon, Mr. Ford. I have some paperwork here in front of me indicating that according to this document that they're charging you with a burglary of an occupied structure unarmed.
Yes.
I had to look up the probable cause affidavit. I don't know if anyone has a copy of it, but apparently on August 9th, that Mr. Ford is alleged to have reached through a drive-through window at his former employment at Checkers and attempted to steal money from that venue. And I need to set a bond in this matter based on my review of the probable cause affidavit. I do find probable cause.
Your Honor.
Yes, sir.
I'm going to ask, Your Honor, Judge Levine originally set his bond at $50,000, and I'm going to be asking the court to set the bond back at $50,000 for several reasons. One, Mr. Ford was arraigned yesterday by Judge Fine, and my argument would be that at this point, since he's been arraigned by Judge Fine, any bond conditions really need to be determined, any change to the bonds needs to be determined by Judge Fine. Secondly, as you can see from the probable cause affidavit, it's very clear on its face that this was a burglary of a structure and not a dwelling, since it clearly alleges this took place at a Checkers. Lastly, Your Honor, Mr. Ford's being held no bond. When he was arrested, he was out on bond at the time on a case, and the counts include burglary of a dwelling, 8 counts of dealing in stolen property, 8 counts of false ownership info on a pawn item, and 1 count in grand theft. And I would seem that Judge Levine obviously took that into consideration when setting the bond.
Anything on behalf of your client, Mr. Reedy?
Well, Your Honor, what the state says is true. He's being held no bond on counts 4 through 21.
So this is a change
So-
of charge for the record.
Right, and I just asked the court, I think burglary of an occupied structure, I'd ask for a $2,500 bond. I really don't think Mr. Ford is going anywhere right now anyway.
No, ma'am.
I guess-
I currently take care of my mom's caretaker. I'm not going nowhere. I take care of my mom. I stay home with my mom. I'm just trying to get home and keep her from going to a nursing home. Long as I be in here, she have no one home helping her. So I'm just trying to get back home so I can keep her from going to a nursing home.
Well, Mr.
That's
Ford,
it.
I'm sorry for the circumstances regarding your mom, but unfortunately, no matter what I do today, it's not going to affect your ability to go home because I'm only talking about one of your charges that they changed a little bit, and it's more of an administrative matter than anything else. You have some other counts that you're being held no bond on, so anything I do today really isn't going to be able to affect how you get home. I think the best thing for me to do right now is to just leave everything exactly the way it is. You saw Judge Fine yesterday. Your lawyer will work up your case, and depending upon what happens, maybe you'll get home. I don't know, but I'm going to go ahead and maintain everything the way it was. I'll find probable cause based on the change of charge, and wish you the best of luck, sir. Thank you.
Thank you.
It was,
50,000.
sorry.
All right, then we have Victor Ortega.
Mr. Ortega's here, present judge at Maine.
Okay.
He declined the services of public defender, judge.
All right, very good, Mr. Ortega, good afternoon.
Good afternoon, Your Honor.
You're here for your first appearance, probable cause hearing. You do have a right to have an attorney represent you at this and all hearings. My understanding is that you do not wish to use the services of the public defender. Please understand that everything that's being said right now is being recorded, so please do not talk about the facts of your case, because if you say anything, it can be used against you. What I'm here to try to determine right now is what your bonds should be. According to what I have in front of me right now, you have a possession of cocaine and a possession of alprazolam. I've reviewed the documentation here. I do find probable cause for your arrest. According to this paperwork, right now, you're being held on a $1,000 bond for count 1 and a $1,000 bond for count 2. If you don't believe that anyone can post those bonds for you, a total of $2,000, I would be willing to listen to you about whether I should reduce those bonds or not. If you think that you can get those posted, it's probably best that we not have any more conversation. So do you think you can post these bonds?
It's full, the full $2,000?
It's no, well, I think if you go through a bondsman, they require the 10%, is my understanding.
I'll pay that $2,000.
Okay, all right, very good, sir. So, you'll post that bond, and then you'll get your you'll get your next hearing date in the mail, and then you'll just work on hiring your own attorney, okay?
All right.
All right, good luck to you.
Question.
Yes, a question, go ahead.
I haven't spoken to none of my family members. How would they know to?
Do you need access to
I just
your
need
phone?
a phone so I can call my father or one of my cousins to come get me.
Do you know the phone numbers of who you need to call? Yes? And
Yes, ma'am.
doesn't he?
If you ask the deputies, they should be able to assist in getting him access to a phone there to make a call.
Yeah, but she told me she's gonna try to.
Kim, I don't know how it works. Doesn't he
All
have
I know is
access
that
to a
everybody
phone?
keeps saying
supposed
that there's a voicemail. I want to speak to my father.
Okay,
That's all.
so they've called and
It's
they're
my
getting the
cousin.
person's voicemail.
Oh,
So have you tried calling your father?
that's different.
I haven't.
Okay. And you gave someone the phone number for your father, and they get
Yes, I have. Yes,
and they
yes.
just keep getting a voicemail
Well, the lady that just asked me told me she got a voicemail.
for your dad.
Yeah.
Okay. All I can do is just have you ask them to call again and leave a message to come down and bond you. Is all I can do for you, sir. I'm sorry.
All right, I
Okay.
understand.
Okay. All right. Good luck to you, sir. Okay, and I believe that takes care of the regular docket, and then we have some motions for release.
And yeah, 1 second look also.
Okay.
We only have one more person left here at Maine, Judge.
Okay, and who might that be?
What's your name, sir? Terrence Walker. Mr. Terrence Walker, I believe he's here on a 30-day ROR motion?
Yes, he is. He's on page 3 of the docket.
Yes. Your Honor, the state has not yet filed an information. Mr. Walker is entitled to release on these charges at this time.
Apparently legally I have no other option but to go ahead and release you, sir. Please understand at this time you're being released. It doesn't, I see the smile, but please understand that does not mean that you're out of the woods yet. There's a possibility that the state will be filing these charges against you. You'll receive notification in the mail in the event that they decide to charge them, in the event they decide to charge you, and you'll get a new court date, okay?
Thank you, yes, ma'am.
Stay out of trouble, sir, so you can keep that smile on your face, okay?
Yes, ma'am.
All right.
Yes, ma'am.
Good luck, sir. Judge, we're done here at Maine. I'll see you tomorrow.
No, I'm not here tomorrow.
Judge
Sorry.
Benson.
Another judge will be here. It was very nice to see you.
Take care, Judge.
Okay, and where's the rest of our folks?
What's that? Yeah. What's that? Yeah, he is. Parlayed? He's on the phone.
So where's the rest of our docket? At what
I guess
jail?
just go through one by
What
one.
well, no, I meant the jails.
Yeah, that's what I'm saying. If
Oh,
you-
okay, okay.
They're probably mixed up, all the different ones.
So let's go ahead and go back to this docket. So we have a Miss Ward. Where's Miss Ward?
North Broad, Your Honor.
Thank you.
Brian, I don't know if you reviewed what's
All right,
going
Ms.
on
Ward,
here.
good afternoon.
I don't know if you reviewed
Uh,
what's
you,
going on
hello,
here.
you have two cases pending right now, and it doesn't appear that the state has filed
Well-
charges against you.
Well, Your Honor, actually, and I don't know why the 2528 case is on the docket. That, she's being held no bond. That was actually filed in June. She failed to appear at her arraignment, and she's being held, she's got a status hearing October 12th in front of Judge Tobin Singer on that. That shouldn't even be on the docket.
Okay, so the only one that we're here to determine whether the charges were filed was the,
102.
10271?
That's correct.
Okay, and that, in that case, her
That
charges have not been filed
Have
yet.
not been filed. She's entitled to an ROR on that charge.
Okay,
on
all right,
those
so
charges.
Miss Ward, the good news and the bad news. The bad news is you still have to stay in jail because there's one of your charges has been filed and you have a hearing date coming up with that judge. The good news is the other case has not been filed against you yet, so on that one, you're entitled to an ROR, okay?
Judge, that depends if if Ms. Walker wants to be ROR'd. The problem is that if she gets ROR'd on the second cocaine possession charge, she will cease getting time served for that, and she'll still be in jail on the no bond hold from the first possession of cocaine charge. So, Ms. Walker, the judge can release you on that one charge. You'll still be held no bond, and you wouldn't be getting any more credit for time served on that case because technically you'd be out of jail on that charge. You want the judge to release you on her own recognizance, understanding that you won't get time served?
How can I hold her on a charge that hasn't
She
been?
can withdraw the motion.
I don't understand.
She doesn't understand what you're saying.
All right, Ms. Ward, you have two charges, two possession of cocaine charges. One of them, you're being held no bond because they say you failed to appear in court. So you're not getting out on that. Nothing's going to change about that today. On the other possession of cocaine case, because the state hasn't filed charges in time, you are entitled to be released on your own recognizance. The judge can release you. If the judge releases you on that charge, you'll stay in jail, and you will no longer be getting credit for time served on the case that you've been released on. Do you understand?
Do you need a few minutes to talk to him privately?
Okay.
All right, let me give her a call.
Okay, so we're gonna skip you for just a moment, all right? All right, so we'll go back to Miss Ward. We took care of Mr. Walker. Next we have is John Schultz.
Hey, Deputy, can you have Ms. Ward?
Conti.
Thanks.
All right, on Mr. Schultz.
Yes, ma'am.
Well, let's take a look at your paperwork. You, your charges have not been filed yet, sir.
No, they have, Your Honor.
They have?
Yes,
Okay.
and I checked, it's in Odyssey as well.
Okay. All right, so the state has filed the charges against you, so you're not entitled to a release today. Your bond will remain in place, okay?
Thank you, ma'am.
All right, take care. So that motion's denied. And do I have to put, can I put the, just as previously, or do I have to write in, I don't know what his bond. You- oh, Okay, so I don't have to put the bond set at?
No.
Okay. Okay. Thank you. All right, so that takes care of that gentleman. Then the next one, we have, Ravi Conti?
Yes.
Okay, it's right in front of me, all right. Is that been, those
Well,
charges been filed?
here's the thing, Your Honor, they haven't, however, because of when this arrest was, guys,
Do you still have time?
well, Your Honor, I want to count again, but I believe today's the
You know
30.
what, let me stop
Yeah,
for just a moment.
thank you.
Because I think the only public defender we
Yeah,
have
yeah.
is this gentleman, and so I can't have him doing two at once. So, sir, hold on
Absolutely.
for us just a second, we're gonna take a brief break.
Okay. Oh, man.
Yes.
Okay, we're back on the record, and we're working on page 4 of the docket. The state was just about to explain to me the circumstances on Mr.
Randy Rembrandt.
Your Honor, today is the 33rd day. However, because the 7 days that the courthouse was closed due to Hurricane Irma occurred during this 33-day period pursuant to the administrative order from the Supreme Court, the state is entitled to 7 more days.
Any response to that?
That's what the administrative order says, Judge. I've reviewed that order myself. I don't know why they would need another 7 days on a DUI, but
Because none of us were working, and we were all trying to make sure that everyone was safe, and there would be no way for those 7 days to be utilized in preparing this case for filing.
no, by the way, I was here.
I was here too. I came.
So, Your Honor, with the 7 days, and I have no problem with resetting it for October 12th.
Okay, we'll reset him for October 12th to see if the state's made a filing decision there. Sir, I can't release you today because the state is entitled to 7 more days to make a determination if they're gonna file any charges against you, so we're resetting you for October 12th. You still have your bonds in place if you wanna try and bond out, otherwise we'll see you on October 12th to see if they file charges against you, okay?
Is this for one charge or is this for all my charges?
For all of your charges,
Okay, thank you.
okay? All right, good luck to you, sir.
We can recall Miss Ward if you want to, Judge.
All right, we're going back to Miss Ward, she was at North Broward, I believe.
Yes, ma'am.
Back to Ms. Ward. Ms. Ward, you've had an opportunity to speak with your attorney regarding whether you should withdraw your request to be ROR'd on that one case, yes?
Yes,
And you feel that you understand everything explained to you?
yes,
And you understand that I believe he's recommending that you not be released, but it's my understanding that you've made the decision that you want to be released?
yes.
Okay, you understand that even though I'm signing this paperwork to release you on your own recognizance on that particular case number, you're still being held on another case number, so you're not going home, you understand that?
Yes,
All right, very good. I'll go ahead, based on the fact that the state has failed to file charges in case number 17-10271 CF10A, I will release her on her own recognizance. Good
Thank
luck
you,
to
Judge.
ma'am.
And I informed Miss Ward she has a court date coming up on the 12th, so.
Okay. All right, good luck, good luck to
All
you.
right, good luck.
All right, so that takes care of that. We took care of Mr. Schultz. So we have Ricardo Harlade. Where is that gentleman? Which jail?
Should be at North.
No, I have a gentleman sitting on the floor here in Conti. Who do I have at Conti, please?
Is Mason
Sheldon. Mr. Sheldon, why don't you come on up to the podium there?
How you doing?
Good, sir. I'm just looking to see if the state has filed charges.
Well, this is
against you.
actually a second look, Judge.
This is like, oh, it's a second look, I apologize, okay.
It's okay.
So with regards to Mr. Mason, what is his bond currently set at?
I believe it was set at $1,000. Well, let me check. It is set at $1,000. Also, when he came in, he had an open felony possession of cannabis and drug paraphernalia, which it appears was resolved since then. So this is the only thing holding him now.
And what's that, and what's his bond on that right now?
On the battery, it's $1,000.
Okay, and is the public defender requesting that I reconsider that bond? Or,
Yes, Your Honor, I am.
okay, I'm happy to hear your presentation.
Well, I didn't get it, I only get the second look dockets right when court starts, so I don't generally have an opportunity to talk to anybody beforehand.
Well, I'm happy to give you a recess for that. We can take care of that last gentleman and go back to Mr. Mason.
That's fine, Judge.
All right, Mr. Mason, your lawyer wants to talk to you for a few minutes to see if possibly he can convince me to reduce your bond, so you'll hold on for us, okay?
All right, ma'am.
All right, thank you, sir. I appreciate your patience. All right, so we only have one person yet left, or no?
Yes, ma'am. It's,
And that's
Ricardo
Ricardo.
Parlay.
Where is he?
Should be, well,
North Broward? Is anyone left at North Broward? Doesn't appear anyone's left. Did he possibly bond out?
no, he didn't bond out. I'm being told by confinement that they had a docket that he wasn't on. I mean,
I had a docket he wasn't on either. This
yeah,
is a
and
new
then
docket.
the docket that was,
He was an add-on.
you know, well, I'll wait till Mr., because I think,
I didn't mean for you to get on with him just yet. We have one last person who's on the docket, but he was an add-on and nobody brought him.
What I would ask, Your Honor, is, it is filed, I checked,
Oh,
it's
it's
in
filed?
Odyssey that it's been filed.
Okay.
So I would ask the court to deny the motion. I have no objection if Mr. Reedy wants it reset to have him brought back to be informed of what happened today, tomorrow. It's just that today is the 33rd day, so a ruling has to be made today.
And what jail is he at?
He's at North.
Okay, and they can't bring him down for us?
I don't know if anyone's there anymore at
Okay.
that room.
Okay, all
So
right.
if we could reset him, Judge, so that he has an idea what's happening tomorrow.
That's fine, but I'm denying the motion for ROR today.
Right, I understand.
Okay, all right, very good. So we'll put him back on the docket for tomorrow, just to let him know. And then last but not least is Mr. Mason, and he will speak to his attorney while we were off the record for a quick break. Thank you, sir. You've had a moment to speak with your attorney. This is, are you going to be requesting a bond reduction?
I am, Judge. Mr. Mason has been living here in Florida for the last 25 years. He has been living in the same residence for the last 18 years. He lives with his mother. He went through the 11th grade in high school. He does not currently have a job, but he has some applications, I think he was saying. He has some applications in. He expects to have work very soon. I have received his brother's phone number. I'm going to call his brother after court. He thinks his brother can come up with some money to help bond him out, but I don't know if they can come up with the full 1,000. I'd ask the court to consider a $500 bond on Mr. Mason.
I'm trying to find his probable cause affidavit.
If it's not in Odyssey, I can print the court a copy.
I was looking at Odyssey, it doesn't seem to be attached to anything.
Note that I have indicates the victim
Oh, yeah,
advised she
I'm-
does not want to prosecute. Is that correct?
I don't have anything indicating, but regardless, there's also an independent witness. Your Honor, if you pull up, your.
I see it.
Okay.
Okay.
Yeah, it says she does not wish to prosecute. There was an independent witness.
It says in there that the victim advised she does not wish to prosecute, but there was an independent witness here.
Right, I'm not saying the state can't establish their case down the road, but I think the fact that the victim doesn't want to prosecute tells the court a number of things about the strength of the state's case. Certainly would seem to indicate that this victim is not afraid of Mr. Mason. And maybe we'll eventually be signing a waiver of prosecution form, I don't know. But it's certainly something the court can consider in relationship to bond.
Absolutely. Mr.
And, Your
Linder,
Honor,
what's
Frank-
his background, and tell me what your comments are on
Oh,
the actual
well-
charges.
If you still want to hear his background, I have no objection to a reduction to a $500 bond as long as the no contact order remains in place.
Okay. All right, then I'm gonna go ahead and reduce the bond to $500, and hopefully your family can post that, or at least 10% of that. Whatever, though, you absolutely, regardless of whether this young lady cares about you or not, or is afraid of you or not, until this case is completely finalized, you are not to have any contact with her whatsoever. Either directly or indirectly. You can't have your friends try to contact her, you can't send her a text, you can't send her an email, you can't use the phone to call her, nothing like that. Do you understand that, sir?
Yes, ma'am.
And any violation of that no contact order, if you were to bond out, will result in you being hauled right back to jail, and then you'll be held no bond until this case is finalized. You understand that, sir?
Yes, ma'am.
All right, and the victim's name is?
One moment, Your Honor. It is. Ashley Breedlove.
Okay, you're not allowed to have any contact with Miss Ashley Breedlove. You understand that, sir?
Yes, ma'am.
All right, I'll reduce your bond to $500. Good luck to you, sir, and that concludes our docket for today.
Thank you, Judge.
Thank you.